The next case is State of Ohio versus Selena McIntyre. It looks like we have the appellant only here today. You'll have 15 minutes to present your argument. You are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, or victims during your argument. You can refer to them by initials or terms like the child. We've read the briefs and are prepared to proceed when you are.
Judge Carr, Judge Landriver, Judge Sutton, good morning. May it please the court, I am Richard Kuda-Chief. I am court-appointed counsel for Selena McIntyre. Today, this court has a specific and unique opportunity to make some distinctions about a portion of a theft statute that has been the subject of this appeal and the subject of the trial court below. There are distinctions. You know, the state says, and I note their absence today because I really wonder if they have anything to dispute our arguments that have been made. The state says, well, you know what, we can charge either this and we can charge either that. And that is so true, they can charge this or that. But what they did do is charge the wrong section of the statute. This is a welfare fraud case. Fraud. Excuse me. You know what? It's an intervention case. It's a civil case. But I gotta say, this was one of the messiest trials below. It was so hard to follow. So much going on, from multiple lawyers to confusion of intervention for lack of a defense act, whatever. You know, there was so much going on with the different claims, the different money amounts. I don't think my client got a fair trial. And more specifically, it's a charge of a crime that the state did not and could not prove. And I think it's important, despite the fraud, you know, we have the tenant certification, we have the claims of misrepresentation. And we have as well all of this going on about what my client did. What did she do wrong? My client did not steal money. And that is a critical piece here. She's not alleged to have stolen money. She was alleged to have taken what benefits. This is a civil case and it's not one that should have been filed as a crime.
Counsel, can you go through specifically, there's A1 and A3 in regard to grand theft or theft by deception. What elements do you have to prove there?
Well, in this case, with not being charged with deception, they have to demonstrate that my client did knowingly deprive a person, in this case, the claim of AMHA, of property or services without the consent of the owner. The deception piece on the statute says, you know, you must do these things by deception. And that's what the whole factual basis here is all about. So that distinction is critical. So this court has the ability to make a distinctive opinion as to what's the difference between the two. You can't just rest on what the government is saying, well, you know, we can charge either one. They're in the conjunctive. They're both the same charge.
Yeah, what was the state's theory in regard to lack of owner's consent?
I did not know that. I could not find that demonstrated because what really happened, Judge Carr, is AMHA gave consent for these services. So we ask ourselves, well, what's the remedy, you know? Retro.
Counsel, why did AMHA give consent?
Well, they gave consent initially because my client started living there in 2017. Everything was legit. Everything.
But after that, and when they reduced the amount,
Sure,
why did they do that?
They gave consent for her to be a renter there. And then we have a process of, you know, reporting. And that focuses back into, should we blame COVID a little bit here? Yes, we must blame COVID a little bit here because the rent is based on the tenant's income. Now, their methodology, who can understand that? So in the day, we have Selena going, sitting down in front of the clerk, you know, talking with one another. That's not what happened here. And the reason that this is critical is because this is an intervention case. You can't just sit back and listen to the state say, well, of course, there was intervention, come on, there was a stipulation, they offered it.
You keep
That's not.
mentioning intervention, but the state says that intervention was offered, and that part of every intervention typically is paying restitution, and that the defendant declined intervention because she didn't want to pay that restitution. Did that happen?
They say that happened on the day of trial. That's not how intervention works, Judge Lanzer, you know that. Intervention is a request, you make an application for intervention to the trial court. It's not up to the state to say, we're gonna stipulate or not. It doesn't have to do with this.
Right, but it looks like there was a request and a talk about whether she was eligible prior to her being offered that. It looks that, I mean, that's what the briefs seem to infer.
Judge, there's no question Selena was eligible for intervention.
And in fact offered it, is that right?
The state has nothing to do with offering intervention. That is up to the trial judge. Most importantly, the statute provides if a person is eligible, you have to grant intervention. That's what the General Assembly has done here. That's why it's so critical. This is a mentally ill woman that her initial lawyers started talking about intervention. The trial judge did not want to give her intervention because the trial judge decided she was incompetent or unable.
So would she be, if it was charged correctly, like you said, fraud of a government agency, would she be eligible for intervention in lieu of conviction?
I believe that is true. There's nothing that
I don't believe that fraud or theft from a government agency is eligible for intervention or sealing.
I'm not aware anywhere in the record, Your Honor, where that is said and that is brought up. There's nothing in this record that shows Selena McIntyre was not eligible for intervention.
She was eligible as charged, but you're saying that was the wrong charge.
But it doesn't matter that we're operating under the indictment that
Right.
the critical piece to conclude on this is the trial judge has the authority. Look at the statute. It has the requirement. That's what the
Counsel. The trial court stated it would be willing to consider intervention in lieu of conviction in order to resolve the matter. Is that correct?
well, that
Is
I
that
don't-
correct?
I don't know that that be the case, Judge Sutton. And the reason for that is the trial court said, and this is where the confusion, this trial starts going down, the reality of, well, she's incompetent, she doesn't know what she's doing. That's not true. And so the court orders a competency evaluation that comes back and says she's not incompetent. But the court does not say, I'm going to consider intervention at that point. The court says, you know what the court says? Gee, I don't know if she can plead out here because she's incompetent.
Counsel, didn't the court say that they would be willing to consider intervention in lieu of conviction in order to resolve the matter, but Ms. McIntyre's counsel stated that she had rejected that offer?
Yes, Judge Sutton, that was on the day of trial with her, I believe, third or fourth lawyer. And that goes into the ineffective claim. That's not what the lawyer needs to do. What the lawyer needs to do is say, Judge, wait a minute. This is about a stipulation. We're not here to agree to a stipulation. We're here requesting intervention. Make a decision, because if you don't make the right decision, guess what? We're going up to the 9th District Court of Appeals and talk to them about it. And so as you look at this case more particular, this is about a rent case based on the income. And as I said, the COVID situation is still a concern here because of the confliction, confusion. But the important thing also is my client still lives there. So they decide she has not stolen money, but she has services or something that has back rent. So what do you do with back rent? Everybody else has retro rent, and they pay with what they're supposed to pay, and then they pay the additional amount for the retro rent. That didn't happen here. So the reason the statute has the different sections is to be enabled to demonstrate the behavioral aspects, or in this case, misrepresentation. At the best, Selena violated AMHA policies. And when you also look at the record to see that the state could not prove that she did knowingly obtain or exert control over property or services. She's claimed to have done housing assistance benefits, not money. So she did not deprive AMHA of services or property. Look at the statute, I'm sure you will. That's part of what this is all about. Is this court will distinguish, does housing assistance benefits fall under that part of the statute of property or services? Because she's not claimed to have taken property or services. She's claimed to take these benefits. Now, when you also look at the client, the individual, she suffers from mental illness. She's in a coma, she's in life support, she has depression, she has PTSD. You tell me this isn't an intervention case? And if Judge Lanziger, if you are correct, then that may be, but however, that's not in the record. And I think that's critical, because when you look at the day of trial, the court saying, I may consider intervention, that is not how it works. And that is why this is so important when we look at intervention. Not to mention, well, the lawyer didn't help anything. Now, I'm not here to criticize my colleagues typically. In this case, there are a number of issues that I think are significant. And when you advocate for intervention, which I've done many, many, many a times, let's get to how and why the General Assembly set up intervention to help people. Now, yes, Judge Lang, so you paying restitution during that period. What's the end result of intervention? The case is dismissed, and that's why the state needs to go after this on a civil case, but they don't do that. They go to retro rent. I would also encourage you to analyze the statute in the sense that when you look at deception and misrepresentation, is that the same thing as, depriving someone without their consent? Because there's no question that AMHA gave consent for these services. So we have that piece. And so there's no evidence that, who's the owner? I ask you, who's the owner in this case? Today, with the shutdown, would AMHA services be cut off? Who's the owner? The state never proved who the owner
It
was.
sounds like from the way the state wrote the brief that the theory was that it was money that was deprived, not services, that she would have still stayed at AMHA housing, but she would have paid more rent based on her income, so that the false income caused her to pay less rent or no rent when she should have been paying some rent. So is the theory really services, or is it the money she should have paid?
But she's not charged with stealing money. She's charged, and that's a piece of critical importance here when we look at the elements. I understand what the state says, and that's what the whole theme of this thing was, and that's why it was so messy. I mean, if you look at this transcript, oh my gosh, the dollars and the review and the audit, who can understand all that? And that's why the jury lost its way in this case. It was so confusing and so conflicting that, well, she must have done something. So you have a mentally ill person who thought she was on disability, who didn't know that she was, or she failed, or she misrepresented, or she fraudulent, but she didn't steal. And so when you look at consent, and you look at retro, and you look at housing assistance benefits, you look at COVID, this could not be proved, and it wasn't proved beyond a reasonable doubt. Why? Because the charge does not support the factual basis under which the state provided evidence. Now, it sounds good, how they went through it, don't get me wrong. They painted a beautiful picture, but the reality of welfare fraud is not like that. Welfare fraud. Now, I don't have many cases like that. Like the older days, I had welfare fraud cases, and we had a different methodology, but we asked the question, what did Selena do wrong? So if she misrepresented, that's not what she's charged with.
Counsel, before, I know you're running out of time, so what evidence is in the record that she is still a tenant at AMHA housing?
That would be, you can see in the judgment entry that, the judgment entry was revised. I had that revised because that was yet another mistake. They provided a wrong judgment entry but it says in there that she still lives there. Just in conclusion, no question that Selena made mistakes. This is a civil matter. It's a welfare fraud case. It's an intervention case. She just didn't get a fair trial. You don't stipulate to intervention and payment. That's not what it's about. If you get intervention, you got to pay restitution during that 12-month period. When it's done and over, the case is dismissed. In conclusion, look, I don't like to badmouth my colleague, but I'll say this. When you move for an acquittal, put something on the record, would you please, so that the 9th District Court of Appeals can see what you're saying. With that in mind, if you have any more questions, I will rely upon my reply brief for the state's appellate brief. I want to thank the court on behalf of Selena McIntyre for your attention today.
Thank you.
Thank you.